The Supreme Court's verdict today on child marriage has raised some important questions vis-a-vis prevention of child marriage versus personal laws. The Supreme Court today doubled down, saying law on child marriage can't be stunted by personal laws, but on a question that can the Prevention of Child Marriage Act prevail over personal laws? The court said the decision is pending before the Parliament, even as the centre has urged the Supreme Court to give the Act precedence over personal laws. The Supreme Court made some very important statements, also speaking of betrothal of children, which is different from child marriage, saying betrothal of children or minors robs them of the free will to choose a life partner. Also emphasizing several other measures that should be the focus while dealing with the issue of child marriage, from prevention to protection to penalization. But what's the proposed amendments that's before the Parliament, which was also referred to by the Supreme Court? Here, let's just take a very quick glance. It states 18 instead of 21 as the minimum marriage age for women and overrides any other custom permitting child marriage. Proposing assistance and rehabilitation support, imposing penalties on individuals facilitating child marriages, provisions for punishment up to 2 years, fines as well. The bill, though, was referred to the Standing Committee in 2021 and is still pending a final go-ahead. When looking at customs and personal laws, often the Muslim personal law takes center stage, where age of 15 is considered marriageable age for girls. Girls eligible to marry after puberty. In fact, contrast this with the general legal age of marriage set at 18 years. For a marriage involving a minor, consent of a guardian is required. It is said that girls under 18 can reject marriage. How much of that happens in reality is also something that has always been up for discourse. The issue gets even more complicated amid the political discourse around Uniform Civil Code, even within courts. It's not been a straight road to deciding on justice either. Let's just look at this very controversial judgment really by Punjab and Haryana High Court in June 2022. It's controversial because it upheld personal law but had a very different interpretation and directive from the Supreme Court. So Punjab and Haryana court went on to say that marriage of a Muslim girl is governed by a Muslim personal law. So any Muslim girl who is above 15 years of age is competent to enter into marriage. So it essentially upheld the Muslim personal law. Now the Supreme Court went on to say and ordered all the courts that don't treat the Punjab and Haryana High Court as a precedent. That's what the Supreme Court said. And in fact, the Kerala High Court, while looking at similar instance, also went on to say that there is a ban on child marriage and it's applicable to all. Child marriages deny the children the basic human rights. But which are the states with higher instances of child marriage? Because many often we, as Indians in 2024, seem to think that this does not happen in India much, and so on and so forth. The Lancer Global Health report that looked into 1993 to 2021, that is almost 30 years, states West Bengal has a whopping 51.4%, it just went past. Tripura at a 40.2%, Bihar 38.7%, Assam 31.9%, Jharkhand 31.5%, Andhra Pradesh 25%, Telangana 23.4%, Rajasthan 21.3%, Karnataka 20.5%, and I felt it was important to bring out this larger picture because, you know, many of us in urban India may just live in this denial that this does not happen in India or this is very closely linked to a particular state or a particular community. Well, this is a data that we really had to bring out. Let me open this up at this point to our panelists. I'm being joined by Nizam Pasha, who's a Supreme Court advocate, Kapil Madan, who's an advocate as well, Sana Raees Khan, who's a Supreme Court lawyer, and Dr. Sharanya Jaikumar, who's a child rights expert. Thank you very much, all four of you, for joining me. First, Dr. Sharanya Jaikumar, let me come to you. Would you want to take us through, as a child rights expert who's been on a state panel as well, what do you look at when the Supreme Court has given out this judgment today? particularly at the heart of it is child rights, is a very strong message against child marriage. But at the other hand, we do not really know that though it's a given that child marriage should not be happening, when it comes to personal laws, we still may be quite in an ambiguous area. But first question, Dr. Sharanya Jayakumar, while you of course will explain on this, is also the court spoke about personal laws and traditions. Would you want to take this on?
See, child rights stand above everything else, I should say. There are certain reasons why they have said that the legal age of marriage is 18 for girls and 21 for boys. There are a lot of elements that is actually, put together this real important message, because when a child gets married before 18, there are so many things that the child is going to miss in life. Right to development is one of the basic child rights, and that is going to end there. That child is not going to get any education in future. That child, I'm sure the child is not going to get any education in future if the child is going to get married at 15 or 16. The child will be made to believe that this girl is only marriage material, that you have to be a good wife, a good mother forever in life, and that you cannot do anything else in life. That is one major thing. See, we have to understand that as a psychologist, I would say the frontal cortex development of children happens completely after the age of 18. And that is why children are not allowed to ride a motorbike or drive a car or cast a vote or get married before the age of 18, because their decision making is not right. They may not choose the right person. So even if there are religions and traditions that said, I am giving the option to the child to choose the partner even at the age of 15, the child will not choose the right partner. And Sneha, I must say, in so many extramarital affair cases where the lady involved has hurt her children just to leave her husband and go with another man. There are so many such cases I've handled in Tamil Nadu. When I was handling one such case, when I went to this lady and asked, why did you do this to your child? She was about 23 years old and she was beating up her children just because she wanted to go with someone else. So then that lady said, when I was 16, I got married. I just got married thinking it was like a birthday party, because that's how her family convinced her. You'll get clothes, you'll get gifts, you'll get married, it'll be a nice party, it'll be fun and all of that. But it's not a one-day affair. It's a lifelong commitment. And then at the age of 21, 22, they realize they don't like that person. And then they make other choices in life. Thus, there are so many other problems coming. So before 18, even if there are traditions that said this, I think the basic child rights is violated if a child is getting married, a girl is getting married before the age of 18, or a boy is getting married before the age of 21.
Dr. Sharanya Kumar, let me just come to you for a second question as well. And this is important. I'll possibly give you 2 minutes because I have to go to others as well for their introductory remarks. Do you see this as a community problem? Do you see this as a state problem? Often, you speak about one particular personal law that allows for marriages at a much younger age. How do you really see this? Because we went through data and statistics across the states. This is from the Lancer report of the health. And we came across several states that have relatively a higher percentage when it comes to cases that have been registered of child marriage. So can you decode this for us? How do you look at this?
See, when we went on child marriage rescues in so many other states as well, there is a large community of people that actually protect their own children, telling, we are getting them married because we are there to protect them. And you are trying to free them and send them to school or send them to college, and they become vulnerable. This is what they believe in. So there is always a problem in enforcing this law. See, actually, the DSWO, the District Social Welfare Officer, is the nodal officer for prevention of child marriages. So when she goes and tries and stops a marriage in a village, then the whole village gangs up together against her, and then they want to stop this whole rescue process, and they say, get out, we know what we're going to do with our child, we are there to protect the child better. And this is what is happening in most places, and that is why it's getting very difficult to implement the Prohibition of Child Marriage Act in so many other places. Especially there is involvement of religious groups, religious leaders, who actually come and protect the child and say the child cannot be rescued, this is what the child will go through, and there is a big fight happening. Even the rescue process gets very difficult.
Is this across religions, couple of religions, or is it largely to one religion?
No, I should say couple of religions. I will never say one religion. Predominantly, yes, there is one religion I don't want to mention, but most other religions also do the same thing. I must mention in Christianity, it's very, very less, because they have to get the approval of the church. The church gives an approval to marriages only if the girl is 18 plus and the boy is 21 plus. But in most other religions, it is happening, I should say.
Okay, let me just get in Sana Raees Khan at this point. Sana, how do you look at what's happened in the court today?
See, child marriage has a devastating impact on many aspects of children's lives, including their physical, psychological, and emotional development. So I view it as a public health issue as well as human rights violation. But if you see the judicial, in terms of judicial precedent, Supreme Court has already, in this landmark case law in Independent Thought versus Union of India, has already ruled that sexual intercourse with a wife below 18 years of age constitutes rape. So even if the marriage takes place, even if the marriage took place under personal law. So this decision reinforces the idea that child marriage, even if it is allowed by personal law, violates fundamental rights. And in fact, even child marriage, several high courts have also taken similar decision, that and observed that act has extraterritorial jurisdiction and is applicable to Indian citizens living abroad, regardless of the location, and to all citizens, irrespective of their religion. So I definitely advocate for progressive interpretation of Islam that upholds and ensures that Muslim children, like all other children in India, are protected from harmful effects. So if I can just speak about a progressive interpretation of Sharia, Sharia is not static. It is based on principles of justice, compassion, and the well-being of community. So preventing child marriage under the PCMA is in line with these principles, and it protects most vulnerable members of the society, that is children. Again, Islamic law has certain objectives that includes the protection of life, intellect, and lineage. So again, child marriage undermines several of these objectives, particularly the protection of life and interest. Then again, speaking about the fundamental rights of the child, early marriage denies children, especially girls, their right to education, personal development, and health. And Quran itself stresses the importance of protecting vulnerable individuals and promoting justice and fairness. So early marriage without consent or maturity of the individuals can also lead to injustice. Yes, injustice, harm, contradicting the spirit of Islam. So the Quran itself advocates for marriage as a means to build healthy, supportive family, but this is based on the premise of maturity and mutual consent. So again, just like equality before law.
Sana Raees Khan, while you've said this, let me just go to Nizam Pasha very quickly. Nizam Pasha, do you see the same interpretation as Sana Raees Khan has said? Because the court went on today and literally that whole debate around child marriage vis-a-vis personal laws, traditions across the country has been reignited. And one would ask a very simple question in 2024, why does a personal law or any tradition need to be upheld when it comes to preventing, prohibiting child marriage? While I am saying that, it's also something that the court has said is before the parliament to decide. But Nizam Pasha, how do you look at this?
I'm not going to defend a number or a particular scripture of a particular religion or a particular community. But what I would want to highlight is that we tend to overemphasize the role of law as the instrument of social change. And what the Supreme Court judgment has done is that it's also put a lot of focus on societal interventions, because law isn't, not only is it not the only instrument of social change, but it can also often be the most inefficient and the most harmful instrument of social change, because criminalization is not the solution to a cultural problem. Criminalization is also not the solution to a societal problem. It may be education, it may be empowerment, it may be any number of things, community initiatives, society initiatives, which the judgment has spoken of. But when you take a practice prevalent in a community, in a particular community, and you criminalize it as the way of dealing with that practice, then a community which is already vulnerable, you are making them even more vulnerable because there's one more law that they can fall foul of. So instead of having softer approaches, you move straight to criminalization. And while, like I said, I'm not defending a number, but I just want to say that when we fix age for marriage, one thing we have to be very wary of is that there is an element of cultural imperialism in this. That when we say that this number or that number, my number and not your number, what we are doing is that, for instance, Dr.
Sharanya.
Dr. Jayakumar
Yes.
took the example of riding a motorcycle and voting. Now, for young men who are beyond the age of 18 and under the age of 21, they can vote, they can ride a motorcycle, they can drive a car, but they can't choose to get married. And while societally we are moving more and more towards a pro-choice jurisprudence where we initiate, where we encourage people to have a wider variety of choices and sexual preferences, but choosing to be with one partner on a committed basis early on is not seen as merely a sexual choice or a sexual preference. So in that sense, there's also a little bit of double standards that come into this, and that's something I feel that we need to bear in mind when we deal with any law or any change or any judgment that relates to the age for consent for marriage.
You know, Dr. Sharanya, I would like you to come in, and I have Kapil Madan as well to respond. But Kapil Madan, give me just 2 minutes, give me 2-3 minutes. Let me just go to Dr. Sharanya and let me just get her to respond to this. How would you want to respond to what Nizam Pasha has said? Because obviously he's brought in other aspects. And interestingly, while talking about the age of marriage, he's given the male age as an example and not the women's age here. So, you know, that itself is very interesting how that argument came forward. But Dr. Sharanya, please.
See, initially, why the legal age of marriage for girls was 18 and boys was 21 is boys were considered to be the breadwinners in the family. They were the ones who went to work. So if they studied or had some skill developed till 21, then it would be easier for them to, you know, get into a family setup, start earning, feed the family and all of that. But now I think things are changing. So women are also equally contributing to the finances in the family, the expenses in the family. And that is why we have now suggested 21 as the legal marriage age for women also. And it's still pending, as we all know. And very soon, when that is going to be accepted, it's going to become 21 for both boys and girls, which is, in fact, I feel a better state. But already with achieving no child marriages with 18 as the bar itself is not happening. If you push it to 21, there are more and more number of child marriage cases that's going to be registered only. I think that's why it's getting delayed.
Okay, Nizam Pasha, very quickly, you know, while you said you don't want to defend, but you actually went on to defend a number, talking about it has cultural consequences. You know, while we're talking about the personal laws, and the court also spoke about personal laws, I was just going to the Muslim personal law, and help me understand. It goes on to say that girls below the age of 18, if they want to marry, if they're asked to marry, can reject. Does that really happen? It's interesting because the very fact that you're asking somebody below 18, in fact, above 18 is also that case. But below 18, where would the agency be to reject? How would you look at that? And again, let me just put this across. It's not just the Muslim personal law. They also spoke about betrothal, and betrothal is something that happens across communities. So yes, it's not just one personal law. The court has gone ahead beyond it all. But Nizam Pasha, my question to you particularly is about the Muslim personal law.
See, what I would wish to point out is that we tend to ignore that India exists in parallel worlds. It's not one uniform system or society that we live in, there are, in the context of childhood, but in the context of child witnesses, to take an example, the courts, particularly the Supreme Court, had taken a view that on the question of whether a person's testimony, a person who is a child as per the definition, is believable or not, they said will depend upon the context that that child comes from. Because in rural India, somebody who's 12 or 13 is actually a young adult who's fending for themselves and plowing the fields and is a fully functional unit. Whereas in an urban environment, that same person is infantilized to the point that they can't decide what to have for breakfast. And so the Supreme Court took this very contextual view of childhood to say that it depends on context. And when we say that our understanding as an urban Western-looking society of what the appropriate age should be is the only understanding that should be allowed, and everything else should be criminalized, that involves, like I said, two elements: one, infantilizing young adults, and two, ignoring cultural contexts. So criminalization and these hard approaches are not the way to create
let me just get in,
even out.
While you're making that argument of contextualization, let me just get in Kapil Madan as well. Kapil Madan, let's just play the graphics of the states that have recorded the child marriage, the percentage, and particularly with the Lancer report. Kapil Madan, how do you look at this argument of contextualization? Because marriageable age, can it be seen in context? Can it shift based on context? Because that's not the messaging that the Supreme Court gave today. Let's be very clear. The Supreme Court says there needs to be various mechanisms, a holistic mechanism to deal with child marriage. But nowhere did it say child marriage needs to be seen in context.
So, Sneha, I heard my good friend Mr. Pasha here, and I must say here that the context and the example that he gave, was misplayed. He is trying to fit a square peg in a wrong hole. And the example that he gave, that if someone is called as a witness, if there is a child witness who is being called to depose in the court, while recording the deposition, will try to find out what is the understanding level of intelligence while the court records his or her testimony. I think this is completely misplaced. The fact that when a child witness is asked to depose before the court is only trying to test whether the person is in the capacity to depose, understand what has happened, and explain what has happened insofar as what he is required to depose. That's it. Nothing more, nothing less. I mean, applying that yardstick and logic to say whether the same individual has the rationality or the intelligence to understand whether he is being capable of giving a consent or a no consent for marriage is completely misplaced. I think it's absolutely illogical and far-fetched. That's point number one. Now, if you look at what is the context of and what was the reasoning why this Supreme Court judgment came, it came because the court was of the view that a person who is considered as a child does not have a will to decide what is wrong and what is right. And this is not only in the context of a marriage. In fact, the law also protects in the context of contracts. Law regards a person who is considered as minor or who is a minor as per the laws of a country. He is not competent to enter into any kind of transaction. So, having said that, I see this judgment is a very rational and a very well thought, well reasoned judgment, and it's a step towards a progressive society. And I completely disagree with Mr. Pasha here, who was just trying to give a bit of a communal flavor here, wherein Mr. Pasha is trying to portray a situation that there is only one particular community which encourages child marriage, or which the personal law permits child marriage, and therefore you should not penalize because they are already they stand on a negative footing. This is the kind of an impression which Mr. Pasha tried to give. So I don't think, and I absolutely disagree with Mr. Pasha here. To my understanding, I think it's a well thought of, well reasoned and well explained judgment. The court has gone into the fact whether a child has the autonomy to decide, whether it affects the child's right to have an education. It also affects the child's right to or right to have or right not to refuse reproductive choices. So I think it's a very rational decision. It's a progressive decision, and everyone, irrespective of any community, caste, creed, should welcome this decision.
Nizam Pasha, to add to what Kapil Madan is saying, and just to, I would like both of you to speak on this. The court was very clear, it did not mince its words. The court, of course, left the question of whether the act can, whether personal laws and traditions can subvert the act. They left it to the parliament to decide on that. But the court did make it very clear that personal laws must not stunt the act. That is the prohibition or prevention of child marriage. It must not stunt. That's a very clear judgment by the court, Nizam Pasha. So contextualization of the age doesn't really fit on it. The court is very clear about child marriage in this case.
See, there are a couple of things that I want to say. First, Mr. Madan seems to contradict himself because he says that for a witness, the court evaluates the level of intelligence of the individual, but then seems to believe that you don't need to understand the level of intelligence of an individual for purposes of marriage. That's the similarity that I was trying to draw, which seems to have escaped him. Second, he's accusing me of having tried to make this about one community. I actually never mentioned one community. I pointedly avoided your question about Sharia. I'm my own personal identity aside. Just please don't interrupt. My own personal identity aside, I am not. I have not so far mentioned any community, any religion at all. I just said the communities that usually have a higher prevalence of child marriage, and I quote myself from what I said, tend to be the more vulnerable communities in any event, and criminalization leads to further victimization of an already vulnerable community, and that's all that I had said. And as far as the Supreme Court decision is concerned, I started by saying the Supreme Court decision is a great decision. The Supreme Court has left it to Parliament, as it should, because Parliament represents the will of the people, and for an issue like this where there are various ideas of societal morality which are at play, the Supreme Court doesn't wish to step in and legislate. And that's what, so the Supreme Court has given an indication of where its own jurisprudence it would like it to be, but it has deferred and left it to the choice of Parliament. And I started by saying that I welcome the fact that the softer approach of reform and education and societal initiatives that are required, the Supreme Court has moved the focus from criminalization to those. So the judgment itself is actually a great judgment. But only the question which has been left to Parliament, we are talking about that question and whether there needs to be a hard number independent of context.
Kapil Madan, very quickly, 30 seconds, and I would like to go to Dr. Sharanya after that.
Sneha, is that for me? I'm sorry, I missed your audio. Is that for me?
That's right. That's right, Kapil Madan. You have a right to respond. That's why I'm coming to you.
So I'm glad that Mr. Pasha at least agreed that this judgment is a right judgment and it is in the right direction. And the fact that he mentioned about the community, I didn't mention which particular community, but he used the word community, that there are certain communities which are he used certain terminology. So I was just responding to that context, because this judgment, I don't think the court has stressed on any particular community while passing this judgment. The court has talked about the law as such, the issues at length, which will apply. The same yardstick applies to every one, be it from any caste, creed, or a community. So in that context, it's a welcome step. And again, I said that when Mr. Pasha gave an example where a person is required to depose before the court, the only intelligence the court needs to test is that the person who is deposing is competent enough to understand what has happened, and he is able to narrate the same incident to the court.
Okay, we're running out of time, sir.
Nothing more, nothing less.
Dr. Sharanya Jayakumar, again, to our viewers who may be in very urban spaces, who know that their child marriage is a big problem, but they may just say that this happens somewhere in some part of India, isn't really an issue that we need to really wake up to. Just how ingrained is this in the Indian society? And I want to bring this very important aspect of what the court said, and it did not speak only about child marriages, it also spoke about child betrothal. where, I mean, very loosely put, engagement. I mean, that's not how the word is really, but it's committing to marriage while you are children for when you become adult. It's a commitment by families, not the children.
Sneha, I should say, we live in a country where 50% women, 50% men, or 50% male, 50% female. If we are going to bring up the female population just to get married, to settle, only to take care of the family, then definitely we are going to waste 50% of our resources. And that is why we constantly say empower children, give them education, let the gross enrollment ratio, even for the female population, increase, let them go to college, let them earn. The people in the urban areas don't really understand this, but when you go to the real rural areas, you know how many of these children's dreams are shattered. They are getting married at the age of 15 and 16 just because the parents don't want the child to fall in love with another boy in another community, because they believe that if this child goes to college, she will fall in love with another boy in another community. So, as you said, even if it's not marriage, they say at least get engaged, okay? And then you go and do whatever you want, which means it's already blocking this child from her own free will to choose her life partner, even at the age of 21 or 22, because she's already locked at the age of 15 or 16. And I must mention here, Sneha, that the Protection of Children from Sexual Offences Act protects all children below the age of 18, even if it's consensual sex. Okay, so if we have a very draconian, very severe law that protects children from sexual offenses below the age of 18, what are we doing by getting them married at the age of 15 and 16? It doesn't make sense at all. Then why should we be protecting them so much? Isn't it? Sometimes there are parents of, see, let's assume boy and girl in a love relationship, there is some sexual activity happening, and then the girl's family goes to the court, and then the boy's family says, no, it was consensual. The girl was still okay for it, while my boy is 21, I understand, but the girl is 16, all of that is okay, but it's still consensual. It is not consensual. That is not accepted. So we don't have a provision where they get married and they are refrained from any sexual activities until the age of 18. So it simply means her health is going to be spoiled, her future is going to be spoiled, and we are going to miss out on half of our population going to be empowered as good resources to develop my country.
Okay. Sana Raees Khan, you've been raising your hands. Please go ahead.
No, I'm just saying that the Supreme Court view is in consonance with the constitutional mandate also, that enshrines the principle of equality, non-discrimination, and protection of life and liberty. And we talk about women empowerment, but we cannot walk away from the fact that early marriage restrains the potential of young girls by forcing them into domestic roles at an age when they should be pursuing education and personal development. So I think, and of course, we cannot avoid the public health issues also, like increased risk of maternal and infant mortality, malnutrition, and mental health problems. So these outcomes definitely affect young girls who are married before reaching physical and emotional maturity.
Okay, one minute. Kapil Madan, very quickly, can you just tell me, I won't be able to give you more than 40 seconds or a minute. Do you think something like this that the court has said also is a push possibly for those who may be politically interested in that direction for the Uniform Civil Code? Is that a concern? Is that something that you think?
I don't really think so that this is a step in, that direction. If the law in its wisdom, will have to pass, a legislation on Uniform Civil Code, that's a separate, issue. But here the court has reasoned out. It's a, this reasoning is coming out of a judicial, judgment, and it's not the law. In fact, the judgment itself has left it, to the parliament to decide whether they will make amendments, suitable amendments, to make this as a, this act as an overriding effect on the personal laws or not. So I think the court, in the meanwhile, has passed the, these directions, these observations under the constitutional framework, and it is for the parliament to decide whether they would be making these amendments or they would not be making these amendments.
No, that's what I'm asking. I'm talking about how the parliament and the political parties may interpret this. But Nizam Pasha, are there any concerns that you may have at this point about this? Because there are political talks around this as well. And of course, this decision comes. Or do you see them as very separate?
See, the decision is a
Nizam
decision of the
Pasha.
court, and I don't want to attribute politics to the court. But all moves towards uniformity in laws relating to marriage that this present dispensation comes with, that definitely come from a very stated political objective of moving towards of one single law or uniform civil code. And under the 1937 Sharia Application Act, the law relating to marriage for Muslims will be Muslim personal law is a part of that act. And so any move towards the law of marriage becoming uniform is a move towards towards the UCC. But here, what the context for this conversation is a judgment of the Supreme Court, and like I said, that's not something that I see as political.
Correct.
But the larger environment and the larger debate
Right.
in this dispensation, I do see that as political, and I do see that as a move towards a conscious move, step by step towards the UCC.
All right. I think we have a lot more to discuss, but we are totally out of time. I guess one thing that a very clear message that's come out of the Supreme Court is that child marriage does not have any space in Indian society. Nizam Pasha, Kapil Madan, Sana Raees Khan, as well as Dr. Sharanya Jayakumar, thank you very much for joining us.